The government has not issued any such notification, notwithstanding adverse comment by the Supreme Court in the view of the inordinate delay. In the result, the original clauses relating to preventing detention, Article 22, subsist till today, and the prevent provision of the and relevant provision of the Amendment Act 1978 solemnly passed by the Parliament remain in dead letter. Some states have enacted state law unauthorizing preventive detention, which recall the old Preventive Detention Act 1950. It should be pointed out this is the context that the legislative power to enact law preventive detention is divided by the Constitution between the Union and states. The Union has exclusive power of entry 9 of list 1 7th schedule only when such law is required for the reason connected with defense, foreign affairs or the security of India. A state has power concurrently with the union to provide the preventive detention for the region connected with security of the state, maintenance of public order or the maintenance of supplies, services essential to community. Entry 3 of the list that state of therefore to say matter of the abolishing preventive detention of this ground because it is a responsibility state maintain the public order, production, supply and distribution of goods so long as the concurrent power of the state to legislative to preventive detention with respect to the aforesaid ground remains and any of them feels that the feel for the retaining or making state law for the preventive detention, it is the particularly difficult for the union government to impose it will on the such states. Till then, the existence of the Article 22 of the Constitution will be beneficial rather than the prejudicial to the cause of liberty because of the validity of such states laws can be challenged on the ground of contravention of the safeguard laid down in Article 22. In these circumstances, Article 22 continued to be the Constitution as the necessary evil. In these circumstances, Article 22 continues to be on the Constitution as a necessary evil. Article 23, right against exploitation, as an adjunct to the guarantee of personal liberty and the prohibition against the discrimination. Our Constitution lays down certain provisions to prevent exploitation on the weaker section of the society, on the unscrupulous individual, or even by the state. Article 23 says the prohibition of traffic human being and forced labor. A traffic of inhuman being and beggar, such the similar form of forced labor are prohibited and the contravention of these provisions shall be offence punishable according with law. Nothing in the article shall prevent in the state from imposing compulsory services for the public purposes and imposing such services the state shall not make any discrimination on ground only religion, race, caste or class or any of them. Slavery in its ancient form may not so much to be problem in every state today, but a never form such are the label in the Indian Constitution under the general terms exploitation are the no less a serious challenges to human freedom and civilization. It is in the view of Constitution instead of using the word slavery uses the more comprehensive expressive traffic in human beings, which is the includes the prohibition not only the slavery but also the traffic in women or children or the crippled or the immoral or the purposes. Our Constitution also the prohibit forced labor or any form which is similar to beggar. A indigenous system under such landlords sometimes use the compel their tenants to render free services, which what is the prohibited by the clause is therefore the act of compelling a person to render gratuitous services, gratuitous services, and where is the lawful entitled either not to work or the receive remuneration for it. The clause therefore does not prohibit forced labor as a punishment for the criminal offense, nor would it prevent the state for imposing compulsory recruitment or the conscriptions for the public purposes such as the military or even social services. Article 23 has an element of force. Special provision for the protection of children is made to Article 24, which says no child below the age of 14 years shall be employed to work of any factory or mine engaged or any other hazardous employment. It is to be noted that the prohibition imposed by the article is absolute and does not admit any exception for the employment of a child in a factory or mine or any other hazardous employment in a railway or a port. The Supreme Court directed that the children should not be employed in hazardous job in factories, and positive steps could should be taken for the welfare of such children as well as improving the quality of their life, and the employers of the children below 14 years must be compliant with provision of the Child Labour Prohibition and Regulation Act, providing the compensation, employment of their parents, guardian, and their education. Article 25 to 28, freedom of conscience and free profession, practice, and propagation of religion. India. Article 25, freedom of conscience and freedom free profession, practice, and propagation of religion. India, under the constitution, secularism is to say a state which observes a attitude of neutrality and impartiality towards all religion. A secular state founded on the idea that the state is concerned with the relation between the man and not with the relation between man and God, which is the matter for the individual consciousness. The state shall treat all religion and religious group equally and with equal respect without any manner of interfering with their individual rights to religion, faith, and worship. There is the no justification for the interfering in someone's religious belief by any means. The attitude of impartiality towards all religion is secured by the Constitution by several provisions. Article 25-28. Firstly, there shall be no state religion in India. The state will be neither establish a religion of its own nor confer any special privileges upon the particular religion. It follows from this that the state will not compel any citizen to pay any taxes for the promotion or maintenance of the particular religion or the religious institution. Article 27. No religious instruction shall be provided in any educational institution wholly provided by the state funds, even though the religious instruction be imparted in educational institution recognized by or receiving aid from the state. No person attending such the institution shall be compelled to receive that the religious instruction without the consent of himself or of his guardian. In case of appeal, be a minor. In short, while religious instruction is totally banned in state-owned educational institution, in other denominational institution, it is only the totally prohibited, but it must not be imposed upon the people other than religious without their consent. Article 28. Secondly, every person is guaranteed to freedom of conscience and the freedom of profess, practice, and propagate his own religion subject only to restriction imposed the state of interest, public order, morality, and health, so that the freedom of religion may not be abused to the commit crime and antisocial acts as commit the practice infanticide and lie. To regulations or restrictions made by the state relating to any economic, financial, political, or other secular activity which may be associated with the religious practices but do not really appertain to the freedom of conscience, to measure the social reform and from throwing upon the Hindu religious institution of the public character to all classes and sections of Hindus. Subject to above limitation, a person in India shall have the right not only to entertain any religious belief but also the practice observance dictated by the such belief to the preach of the views of others. Article 25. Thirdly, not only there is the freedom of individual to profess, practice, and the propagate of their religion, there is also a right of guarantee to the very religious group or denomination to place to establish, maintain institutions for religious and charitable purposes, to manage its own affair in matter of religion, to own the acquire movable immovable property and administer such property according with the law. Article 26. To those who have any idea as so as to what of religion plays in the entire being of the common man in India. The bold pronouncement in the above article must appear to be asto- ast- astoundingly progressive and more so if we are considered that while the other half of truncated territory consisting a large mass of Hindu minority has adopted Islam in the state of religion in the constitution. India stands firm regardless of the environment. It is noted that this is guarantee available not only citizen India but all persons including alien. In the admit of freedom of religion guaranteed by Article 25-26 has been widened by the judicial interpretation that all guaranteed by Article 25 and 26 is the right of individual to practice and propagate not only matter of the faith or belief but also all these ritual and observe which is regarded as the integral part of religion as the followers of its doctrines. Of course, religion is the matter of faith, but it is the necessarily theistic. There are well known the religion of India like Buddhism, Jainism, which do not believe in God. On the other hand, though a religion undoubtedly has its basis in system of belief or the doctrines which are regarded by those who profess the religion as conducive to their spiritual well-being, it could not be corrected to say religion is nothing is but a doctrine of belief. Similarly, each religious denomination or organization enjoy complete autonomy in the matter decided as to what rites and ceremonies are the essential according to the tenets of the religious they hold. Regulations by the state again cannot be interfere with things which are the essentially religious, but the court has the right to determine whether a particular rite or observance are regarded essential by the tenets of particular religion. So ends to interfere as the particular practices offend against the public health or morality or not being an essential religious practices contravenes any law of social, economic or political regulations. It should be pointed out in the context that the word of secular is a diverse word capable to diverse meaning and one of dictionary meaning is the concern with the affair of word opposed to religious affair. This is not only caused confusion amongst teachers of the political science and law of India, but has also been taken advantage by the interest of party. This is state confusion has been set to rest. Authoritative pronouncement made by the Supreme Court 9 judges decision as follows. Secularism in India does not mean that the state should be hostile to the religion, but it should be neutral as between the different religions. Every individual has the freedom to profess, practice his own religion, and the cannot be contented if a person devout Hindu or the devout of Muslim be seized to secular. In use of vague word secular in the preamble would not be override the enacted provision in Article 2530 or Article 351. So the preference of the Sanskrit in the academic syllabus as an the elective subject while not conceding the status of Arabic or Persian or like would not be militate against the basic tenets of secularism. Para 20. The neutrality of state would be violated if the religion is used for political purposes and the advocate by the political parties for their political ends and appeal electoral on the ground of religion offends secular democracy. Para 128. Political and religion cannot be mixed. Para 131. If a state government does this, it will be a fit case of application of Article 56 of Constitution against it. Uh, मैं काम कर रहा हूँ. This is the sense of secularism is to be regarded as a basic feature of the Constitution. In 2018, a constitution bench by the Supreme Court with 4-1 majority or on a petition filed by the Indian Young Lawyers Association under Article 32 of the Constitution allowed the entry of women between the ages of 10 to 15 in the Sabrimala temple. The Supreme Court held that the Article 25(1) has employing the expression all person demonstration and that the freedom of conscience and right to freely profess, practice, propagate religion is available to every person, including women. The right of guaranteed Article 25(1) has nothing to do with gender or For the matter, certain psychological, physiological factors specify attribute to the woman. The Supreme Court held that the compulsory practice being followed Radhe Radhe. At the Sabrimala temple violate that the right of women, Hindu women to freely practice their religion and the denial denudes them to the right to worship. The right to practice religion under Article 25(1) is equally available both men and women. All ages of group profess the same religion. Exclusion entry of women of the age of 10 to 15 years is a clear violation right to Hindu women to practice the religion belief which is the constitution make their the fundamental right religion under Article 25 a dead letter. Hearing the review petition, the several fresh petitions on the issue, the Supreme Court observed that the court should evolve a judicial policy befitting it is a plenary powers to the substantial and complete justice for and the authority in enunciation and of the constitutional principle by a larger bench. The constitutional bench by the Supreme Court with 3-2 majority conferred that the matter to a larger bench of a less than 7 judges. The Supreme Court held that the debate over the constitutional validity of practice restriction to entry of women generally in the place of worship is not limited in this case, but also arises respect to entry the Muslim women in Dargah mosque as also in relation of Parsi women married to a non-Parsi into holy fire palace and a agyari. There is yet another seminal issue relating to practice of female genital mutilation followed by the Audi Bora community pending the consideration before the Supreme Court. In amazing, in amazing that the some Christian leaders asserts that the word of propagate in Article 25 gives the fundamental right to convert people of other faith into the Christianity by any means. By assertion followed by the agitations, particularly amazing because the Sikhs undermine the decision of Supreme Court of the strenuous cases in January 1972, which has been brought by the Christian father who sought to invalidate a Madhya Pradesh Act because the made penal offence to convert to attempt to convert a person means force, fraud, and allurement. Odisha has earlier passed a similar act which used the word inducement in place of allurement, and the constitutionally of the act which is challenged by the several members of Christian community, including Christian society, a professor of geology, and several priests. Both of act has been taken up together by the Supreme Court, and the contentions by the Christian community were rejected in toto by the Supreme Court, laying down a following propagation by law which are the Constitution binding upon the all courts of India. A right to propagate in Article 25(1) gives each member of every religion the right of spread, disseminated the tenets of his religion, say by advocacy or preaching. But it would not be include the right to convert another because each man has the same freedom to conscience guaranteed by every provision Article 25(1) of the Christian relied. The equal freedom of conscience belong to each man under the Article 25 means that he has freedom to choose hold any faith or any choice of his choices and not to be converted into another religion by the means by force, fraud, inducement, and allurement. He act of course voluntarily adopt another religion, but force to fraud, inducement, allurement take away of free consent from the would be convert, even assuming that the particular religion had the right to propagate its tenets by any means including conversion, the state has the right to duty intervene of such executing conversion offended against the public order, morality, and health. Because of the guarantee of freedom, religion, Article 25(1) is the subject to limitation of public order, morality, and health as follows. 25(1) subject to public order, morality, and health, and to the other provision of this part, all persons are equally entitled to freedom of conscience and the right to freely to profess, practice, and propagate religion. If any such right to convert to be considered, such right would be belong to every religion, so that there would be inevitably by a breach of public peace, every religion community carried on a campaign to convert people belonging to the other faiths by the use of force, fraud, inducement, and allurement. The state was Therefore, constitutionally authorized nay enjoined to maintain public order by prohibiting and penalizing conversion, including attempt to convert in force, fraud, inducement, allurement was used the person advocating conversion in a particular case. Exactly what had been done by the MP and Orissa Act. The Supreme Court therefore upheld the constitutional validity of both MP and Orissa Act after rejecting every plea raised on behalf of the Christian parties. After the pronouncement of the Supreme Court, the Arunachal Pradesh legislature passed a bill modeled exactly on MP and Odisha Act, which has been held the valid of Supreme Court and the submitted in President for the a private member Parliament Sri O.P. Tyagi presented before the Lok Sabha in a similar bill which is passed by Parliament would be applicable all states of India. The Christian community once started agitation and demonstration against these two bills. These threats against the server resistance of these measures were passed. They politicalized the issue. The slogan that the campaign against the Christian religion is particular contention of the suppression of truth on the following point. Neither of the disputed bill was the leveled against the Christian religion as such a but also have operated in any religion community including the Hindu, Muslim, Sikh, etc. The resorted to the any these lawful means force, fraud, inducement and allurement in order to convert to member of another faith who is own fault. That all the legal points now raised against these two pending bills were taken by Christian party by the Madhya Pradesh Odisha Act case may be widely definitely rejected by the Supreme Court. Those who are allied to the international charters in the support of freedom to convert have to mention Article 18 to International Convention of Civil and Political Rights 1966, which says that no one shall be subject to coercion which would be impaired with the freedom to have or the adopt a religion or belief of the choice. The freedom of every man to adopt the religion of their choice is guaranteed by the clause 1 of Article 18. The two clauses read together means that every individual shall have freedom to choose their own religion or belief in worship, and his freedom shall not be impaired in the use of coercion by any individual attempting to induce him to adopt another religion. So far as the disputed Indian bill ban the use of force as the means of conversion, it is perfectly in line with the international charter. When the fraud is used, the freedom of choice of the individual should be converted similarly impaired. The only dispute which is the may possibly rise the Indian Christian is as to use inducement or the allurement. But such means to impair the freedom of choice of the individual and its resultant choice or violation cannot be said is to be free within the meaning of Article 18.1 of the International Convent referred to validity used to these two words in the Indian bill, which would rest not the wording of the International Convent, which is resulted in various international factors, but on the interpretation of the word public order model Article 25.1 of the our Constitution, which constitutes the supreme law on his land. If the agitators were dissatisfied with the Supreme Court interpretation, Article 25, they are free to challenge constitutional provision of the disputed bill after they were passed, and so pursued the judges of the Supreme Court has revised their views. The expression of Sten strenuous loss case, but there was not the least justification denouncement of the bill crusade against the Christian in particular, when they are nothing but the codification of the principle laid down by the highest tribunal of the land, and the model of the state which has been improved by the tribunal is the strenuous case. Apart from the foregoing guarantee of freedom, conscience and religion, there were certain general provisions which are the aimed to ensuring effectiveness and above guarantees by prohibiting any discrimination by the state on the ground of religion alone. The state shall have discriminated against the citizen any other matter, Article 15.1, and the particular matter of employment, Article 16.2, only upon the ground of religion. Similarly, discrimination ban regard access to use the public places, Article 15.2, admission into the educational institute maintained by the aided the state, Article 22, right to vote. Where the religious community is the minority, constitution goes further to enable to preserve the culture and religious interest by providing that the state shall not be imposed upon any culture other than the community's own culture. The such community shall have the right to establish and administer educational institute to its choice, and the state shall have granting the educational institute discrimination against the such the educational institute maintained by minority community on his ground that under the management religious community. Article 30. Full compensation has to be paid if the state seek the acquired property of minority educational institute. Article 31A. The expression of minority has been used two senses, one based on the religion and the other on basis of language. Since reorganization of the states in India has been linguistic line. Therefore, the purpose of determining the minority, the units will be the state and not be whole the India. Hence, the minorities have to be considered statewide. It is a relative term and refer to represent linguistic religious sanction of group forming less than 50% of total population of the state. The sum total of above provision make our state more secular than even the USA. Secular nature is our constitution has been further highlighted by the inserting these two words in the preamble by the Constitution 42 42 Amendment Act 1971. A word of caution should, however, uttered in the context with mean the secularism on the safeguard of the minority are exhaustively enumerated Article 50 to 30 and allied provision as the major minority rights to further under Chapter 29 post. If a minority community presses for an extra favors outside this specific provision in name of secularism or other party in a power yield them to political reasons, it might be reintroducing them to vices of communalism from which India suffered so which during the later British regime and which is the father of constitution eliminated from the constitution free India. Communal representation and legislators or the communal prevention in public employment. For instance, in government seek to justify appointment for public offices high or low, not on the ground of the merit, but the ground that the appointee belongs to religious minority, such as the discrimination would violate fundamental right any other community. Article 16 to note the discriminated against on the ground of religion for the like, instead of safeguarding the right of minority community it would deny to right of majority and the majority of communities which as the guarantees by the community itself. Neither the secularism nor minority rights can therefore be allowed a argument of preference in the minority or undermine the national unity of strength involves the confidence of the majority no less necessary, but a minority educational institution has the power to reserve only 52 seat student belonging to own community. An institution retains the minority character as long as continue to achieve two objective enable to such minority to conserve is religion and the languages to give the through good in general education to education belong to such community to such minority to right to establish and administration would include right to have choice to medium of instruction. The Supreme Court summarized the general principle related to establish the administration education institute by minority. The right of minority to establish administrative education institutions, their choice comprises the following rights: the to choose government governing body to whom founder of the institution have faith and confidence to conduct the manage affairs of the institution. The appointed teaching staff, teachers, lecturer, headmaster, principal, as also non-teaching staff to take action if there is a dereliction of duty as part of any of its employees to admit eligible student for their choice and set up a reasonable fee structure to use a properties in assets for the benefit of institution. The right con- conferred on minorities under the Article 30 is only the ensure equality with the majority and with the intended to place a minority in a more advantageous position vis-a-vis majority. There are no no reverse discrimination in favor of minority. The general law of land relating to national interest, national security, special welfare, public order, morality, health, sanitation, taxation, etc. applicable to all. These to equality approach to minority institutions also. The right to establish administration and education institute is not the absolute nor Does it include to right to maladministration? There can be regulatory measures ensuring educational characteristics or maintaining academic excellence. There can be check of the administration are the necessary to ensure that the administration is efficient and sound so as the serve the academic needs of institution. Regulation made the state concerning general welfare of the student and teachers. Regulation laid down the eligibility criteria and qualification for the appointment is also condition to serve employees both teaching and non-teaching. Regulation to prevent exploitation or the oppression of employees. Regulation prescribing syllabus and curriculum study fall under the category. Such the regulation do not any matter interfere with the right under Article 31. Subject to eligibility condition qualifications prescribed by the state being met, unaided minority education institute will have the freedom of appointing teachers by adopting any rational process selection.